All right. Welcome, everyone, and good evening. My name is Theo Liebman, and I'm the Executive Director of the Friedman Institute for the Study of Legal Ethics here at Hofstra Law School. On behalf of the Friedman Institute, myself, and our excellent Institute Coordinator, Judy Black, welcome to part two of our two-part series on the role of the legal profession in a time of crisis. We are very excited to have you all here and to be co-sponsoring tonight's program with Fordham's Stein Center for Legal Ethics. This two-part series was inspired by the release of two extraordinarily timely and important books this year: Lawyer Nation, The Past, Present, and Future of the American Legal Profession by Ray Brescia, and Law Democratized, A Blueprint for Solving the Justice Crisis by Renee, Knake, Jefferson. The books are both, but in very different ways, urgent appeals to lawyers and judges and academics and the public that we need to really rethink our approach to lawyering and the legal system to meet some of the most daunting challenges to access to justice, to the legal profession, and to our democracy that we've encountered in many decades here in our country. Today, we're going to be focusing on Ray's book, and in particular, its attention to the role of the legal profession in preserving our democracy. Ray is an excellent emissary to make those appeals. He is currently the Associate Dean for Research and Intellectual Life and the Honorable Harold R. Tyler Chair in Law and Technology at Albany Law School. His accomplishments and his contributions go far beyond those titles. They are too many to detail here. But it is fair to say that Ray has devoted extensive attention in his exceptional academic practice and public service careers to the issues that we're going to be talking about today, beyond just the publication of his book. We are fortunate he'll be providing some opening remarks to start the discussion in today's program. In part one, just for those of you who didn't see the first part of our two-part series, we looked at the state of the access to justice crisis here in the U.S., and thought about a way forward. The panel focused on some of the ongoing challenges to diversity, equity, and inclusion efforts, the risks and opportunities of developing technologies, and the potential of opening the legal profession to non-lawyers. After I'm done with my introduction, I will put a link to that recording in the chat, so those who missed it can click on that and save it for later viewing. Today, part two of the series, we are focusing on democracy and insurrection. And we'll be looking at arguably the most imminent and existential crisis confronted by the legal profession and our country, which is the moral and ethical duties of lawyers when democracy is under attack. Ray's book provides the perfect primer to discussing this topic. It is a very in-depth and I would say unflinching look at the legal profession's role in our country's history, for better and for worse, warts and all. He first looks at the fascinating and really complicated and often really disturbing mix of motives behind things like the creation of law schools, bar exam requirements, and ethics rules, among other institutions. But he does more than just look at that history. He uses it as kind of a crucial context to understand how we can reconceive what the legal profession can do, what it should do, and for how our profession can really improve access to justice and strengthen our democracy. I really strongly urge all of you to read the book if you're concerned about where we're going and where we can go as the legal profession right now. And I'm going to put links to Ray's book in the chat as well, and also to Renee's book. Besides hearing from Professor Brescia today, we're going to hear from a terrific panel of speakers. We will be reserving time for questions from the audience, and depending on how things go, we might take them as they come. So please put your questions in the chat, and we will get to as many as we can. Moderating today's discussion for us is the wonderful Bruce Green. He's the director of Fordham's Stein Center and the Lewis Stein Chair of Law at Fordham. Bruce has received many awards for his work in ethics, has had a remarkable career as a scholar, a teacher, personally, I can say as a mentor and engaged professional in the world of ethics, including his service as the current chair of the ABA Standing Committee on Ethics and Professional Responsibility. I'm going to turn it over to Bruce in just one second, but I do want to say that this program does give CLE credit So for those of you who are looking for New York CLE, any course codes announced during the program have to be recorded in the attorney affirmation form. And Judy Black just put the CLE materials in the chat, so you can click on that. Record all attendance verification codes that are announced during the program, and then you can send the affirmation form back to Judy Black, whose email is in the materials as well. All right, I'm going to turn it over to Professor Green now to introduce our excellent speakers and get the conversation started.
Fantastic. Thank you so much, Teo. I have to say it is an absolute delight to be co-sponsoring this program with Hofstra's Friedman Center. I am Bruce Green. I chair, I direct the Fordham Law School Stein Center for Law and Ethics. It's a real delight to be here. And I see so many people I know that it makes me incredibly nervous. So I will say, first of all, buy the book. You've already got a little introduction of Ray. And I have the great pleasure to be moderating a panel with 4 terrific people, Ray among them, but also 3 other friends of mine. First of all, Harold Coe, who probably needs no introduction, but is the former dean of Yale Law School. He's now the Sterling Professor of Law at Yale Law School and was the legal advisor at the U.S. State Department, which I think is important because one of the things we'll be talking about is the role of lawyers in government in promoting the rule of law. My friend Rebecca Roife of New York Law School, she's the Joseph Solomon Distinguished Professor of Law there, where she directs the law school's Institute on Professional Ethics, the counterpart to the Stein Center and the Friedman Center, but not rivalrous. And then Stephen Younger, who is now senior counsel at the Nixon Peabody firm and is basically one of the major leaders of the New York Bar in New York State. He was the president of the New York State Bar Association. He's been a leader in the profession in our state for longer than I can count. So that's our panel. We're going to start with a little introduction by Ray, but I wanted to begin by just reading a passage of his book. We're focusing on chapter 7 of his book, which is called A Serpent in the Ear of the President. So you could get a sense of where we're going. And I just wanted to read a couple sentences. What role did lawyers play, if any, in the crowd's actions on January 6th? The storming of the Capitol was not an isolated event. Rather, it was the culmination of a nearly 2-month-long process to challenge the results of the 2020 election. That process not only had lawyers at its center, but in many ways, the legal minds involved in the effort concocted a witch's brew of dubious legal claims and utterly unsupported and at times purely fantastical factual assertions. They served the slurry of advice and exhortation to a president eager to cling to power, regardless of the consequences or the fate of the nation's democratic institutions. So our program, The Role of the Legal Profession in a Time of Crisis, Part 2, Democracy and Insurrection, puts the spotlight on lawyers in the aftermath to the election and both the election challenges in court and to the role with respect to the insurrection at the Capitol. You can guess which side of this Ray is on, but I'll let Ray speak for himself. So Ray, let me turn it over to you to introduce our program.
Well, thank you. Thank you, Bruce, so much for that introduction and to the Stein Center and the Friedman Institute for hosting us tonight, and for our great panelists and those of you who are joining virtually, and to all the ships at sea. I do want to focus on the major crisis of democracy. And you said you can guess what side I'm on. I'd like to say I'm on the side of democracy and the rule of law. And I think everyone on this panel would agree with that they are as well. The book focuses on, if you can focus on 6 different things, but it focuses on what I identify as 6 crises that the profession faces at present, and has faced over the last few years, and I think is still, sort of figuring out, sorting out how to deal with them. First it was COVID, at the same time, sort of the racial and gender justice reckoning that the nation and the profession has faced, the access to justice crisis, the fact that technology is going to dramatically affect the practice of law in the coming years, and then the crisis of disaffection within the community, within the legal profession. The notion that many lawyers suffer from substance abuse, high rates of suicidal ideation, high rates of depression. But today, I want to focus on democracy and the rule of law. As Bruce said, I cover it. I think I cover it throughout, the notion of the rule of law and the lawyer's role in promoting and sometimes weakening the rule of law and democracy. And so that's what I'm going to focus my comments on. And I think that will mostly be the focus of our conversation. But I think we also could talk about the connection between rule of law and the access to justice crisis. I think we can talk about the connection between the racial and gender issues that the profession faces and think of it in terms of the rule of law. But we're going to focus mostly on democracy and the rule of law. And the notion of rule of law can mean a lot of things to a lot of different people. I think that we could go back to notions of self-determination and democracy in Athens. But really, we probably, the best place to start is with the Magna Carta in the 13th century, and the notion that the monarch would be subject to the law, right? That's really where the modern notion of rule of law begins. And then we see it emerging again in the colonies. The arguments about the rule of law and the fact that the monarch should be subject to the laws certainly crop up in the Declaration of Independence and in the arguments for independence. The very first complaint that that's found in the Declaration against the monarch is his lack of willingness to assent to the laws. Then we see, John Adams evoking the notion of, his idea for the Massachusetts Constitution in 1780 is that we should be a government of laws and not of men. We see Thomas Paine in Common Sense saying that if we in the United States, if we in the colonies approve of monarchy in America, the law is king, right? For in absolute governments, the king is law. So in free countries, the law ought to be king and there ought to be no other. Fast forward a few decades, we see Alexis de Tocqueville essentially saying the same thing, that scarcely, and the prominence of law in the new United States because of it, because of the critical role that lawyers played in the democracy that he saw. He said that scarcely any question arises in the United States which does not become sooner or later a subject of judicial debate, that we channel our disputes into the courts. Now, some people may say that that's unfair, that we shouldn't channel so many disputes to the courts. I'm certainly open to that argument, but the rule of law is better than the rule of the streets and of the mob. Fast forward a few years further, and the creation of many New York attorneys, one of the first major bar associations is the Association of the Bar of the City of New York in the late 1860s, and one of the main purposes that the lawyers come together, as Samuel Tilden would say about the creation of that bar association, is that New York City had to maintain its role of prominence in commerce through an elevated character for its bar and a reputation throughout the country for its purity in the administration of justice, right? A few years later, as the American Bar Association is considering the creation of a canon of ethics, George Shelton, a prominent San Francisco lawyer, would say that inappropriate practices by lawyers undermine the rule of law and would lead people to take the law into their own hands because, quote, popular sentiment is crystallized into the belief that unscrupulous attorneys can be found to provide loopholes for the escape of transgressors if the fee is forthcoming. So fast forward to today, and I want to just focus a little bit on three lawyers who have gotten some attention, particularly recently, because of at least two of them recently were set up for significant professional punishment. Jeffrey Clark and John Eastman, the two most recent lawyers in the news. Eastman is referred to as the serpent in the ear of the president, but he also, and that was by a lawyer for the vice president. Eastman was one of the main architects of the false electors schemes, of the idea that the vice president could unilaterally discount the votes of 70 million plus voters. He recently received the recommendation in California that he should be disbarred. Jeffrey Clark, preliminarily in DC, same thing, recommendation that he should be disbarred. Jeffrey Clark's claim to fame was that he wanted to encourage the president to urge the acting attorney general, Jeffrey Rosen, to send a letter to the Georgia legislature, from the Justice Department, saying that the Justice Department was investigating significant irregularities in the voting in the election of November 2020. And because of that, the legislature should take a look at these issues and should likely intervene before the certification of votes. He also said that he recommended to the president that if Rosen wouldn't send that letter, then Jeffrey Rosen should be, Jeffrey Clark, forgive me. Jeffrey Clark should be installed as Attorney General because he would send that letter. Now, that letter, it might have been fine for the Justice Department to send such a letter, but the problem was that it just wasn't true. That prior Attorney General Barr had said, no irregularities. He stepped down. Jeffrey Rosen is put in his place as acting Attorney General. And there was no investigation by the Attorney General. The Department of Justice had not found any problems with the voting in Georgia. So the basis, wielding the weight and power of the Justice Department would have been completely baseless. And that was what Jeffrey Clark was urging. Similarly, John Eastman, I do not think that thousands of people who stormed the Capitol on January 6th had really read the Electoral Count Act, right? Now, I will be the first to admit that in its iteration at the time, it's since been amended by Congress. It was a very confusing law. You might find some hooks in there, but what he was trying to do was to create false slates of electors, none of which had been confirmed by the state legislatures or by the governors in their states, as is required by the act. So to even suggest that there were alternative slates of electors, to suggest that there was a dispute over the legitimate slate of electors was simply not true. And we know, we know a lot of this because of normally one wouldn't have access to internal memos, work product of lawyers, but we do have access to the memos, the emails, because a judge in California found that a lot of Eastman's communications were in furtherance of a crime or a fraud. So we could look at what he was saying. We could look at the advice he was giving to his client and know that he knew that these actions were illegal. He knew that what he was recommending was an illegal course that would, through pure power, try to throw the election into the House of Representatives, where he believed, probably rightly, that the way the vote is counted in such a situation, that President Trump would likely be reelected, right? Lastly, we can look at the many acts of the former mayor of New York City, Rudy Giuliani, acts for which he has already been suspended in New York State, and I believe we're still waiting the final decision on his disbarment. But just one simple act of defaming Ruby Freeman and Shay Moss, two election workers, for which he has suffered a default judgment of roughly $150 million, making absolutely spurious claims about them, and with no basis in law or fact for making those claims. So as we look back on November to January 2020 to January 2021, and we look forward to November and January 2024 and 2025 respectively, I fear that we may have similar forces aligned to try to secure engage in the same kind of conduct. And with these pending disbarments, I hope that sends an appropriate message to lawyers who might consider engaging in this sort of conduct in the future. But if you think about it, what's the worst that could happen if you're a lawyer thinking about this? Well, you could be disbarred, you could face a defamation claim, but you also could get pardoned, right? Now, could a president pardon a disbarment? No. But if there's any illegal conduct, the president, federal crime is committed, one could get pardoned for that. So are the incentives in place now for people to dig deeper, to try harder, to look back at the errors of 2020 and 2021, to try and correct those errors? Were those actions merely dress rehearsal? It's scary to think that they might have been. And it's scary to think that, the lawyers who may prepare for similar actions might be steeled and ready to suffer the consequences, the professional consequences, in the expectation that they'll be off the hook if their schemes prevail. So I recommend in the book that at present, we have rules against frivolous claims. We've got them in the model rules, we've got them in state rules, 3.1, we've got them in Rule 11, 1920, 28 USC 1927, the inherent powers of the court, and virtually every one of these mechanisms have been used in the post-election litigation. Probably my favorite claim that was made in one of these post-election cases. Bruce, you made reference to fantastical claims. My favorite complaint had to be the one that claimed, citing Tolkien, citing the Lord of the Rings, that there is no king in Gondor, and thus a steward, like in Gondor, the executive branch and Congress, are rudderless, and the courts must, like with Gondor, appoint a steward like Denethor to run the federal government. I love a Tolkien reference. Tolkien, Game of Thrones, Stranger Things. I love it, but not in court pleadings. Come on now. And so, we've got those, again, Rule 11, 1927, inherent powers of the court were all deployed well after the fact, after the complaints were filed. I urge us as a profession in the bar to distinguish, to not simply say under Rule 3.1, for example, that there's no distinction, as there is no distinction in the rules between fabricating a medical record in a slip and fall case and trying to thwart the peaceful transition of democracy. We recognize in the preamble that lawyers have a special role to play in preserving the rule of law. And in the book, I recommend that we incorporate stronger rules around actions that might be seen as striving to undermine the rule of law. So I'll stop there. I've said probably more than I should have, but I'll turn it back to you, Bruce.
Thank you, Ray. So I just want to have a conversation between now and 8 o'clock when we have to end. And I'm going to throw out a very general question, and then in the best tradition of punditry, invite the three panelists to completely ignore my question and talk about whatever they'd like. But one of the things that I think about in listening to you, Ray, and in reading the chapter is, those of us who teach legal ethics owe so much to Watergate, and the fact that there were lawyers involved in criminality there, and the bar reacted by requiring legal ethics to be taught, and viewed it as a little bit of a moment of crisis for the legal profession. And so my just broad question is Ray right in his book that we're sort of at an inflection point, that this was a really significant event, that we have to worry about the threat to democracy and the possibility that lawyers, rather than being a restraining force, a force for the rule of law, might be a negative force? Or is Ray just trying to sell books? So that's my question. I don't know. Harold, do you have a response to start us off?
Yeah, let me first say something about Ray. Some people talk the talk, but Ray Brescia walks the walk, and which is why I'm here. I just want to recall that when I was 31 years ago, we had a brief doing the Second Circuit in the Haitian refugee case, and Ray Brescia was a graduate, had just graduated from law school, and he had just taken the bar for 2 days. And he came directly from the bar exam and pulled an all-nighter to help us get the brief done. And I'd never seen anything like that before. Anyway, it's a real pleasure to read the book because Ray captures an enormous amount in a very short span. And he does it through the tool of history. He uses the image of Janus, the god who with two faces. And he looks backwards, as you just heard, and looks forward. And I thought that the chapter that he directed you to, chapter 7 about the serpent in the ear of the president, was a very powerful one. So, Bruce, to your question, those of us who lived through Watergate thought that it was the worst thing we'd ever seen. That the president who's seeking re-election appears to condone the committee to re-elect the president breaking into the opposition's headquarters to steal information and then try to cover it up. But what we've seen with Trump's 2 impeachments is something just at another scale altogether. Both of the impeachments were about election interference. The first one is about whether he condoned election interference by the Russians in the 2016 election where he beat Hillary Clinton. And then secondly, whether he used his foreign policy leverage on Vladimir Zelensky, who at the time nobody had heard of, to try to get him, instead of answering his request for military aid, asked him to get him opposition research on Hunter Biden, and so that he could win the next election. This is an amazing thing in and of itself. He's impeached, but then he's not convicted. And then after he loses the election, he encourages direct domestic election interference by a mob, and what Ray calls using lawyers and legal theories to support mob rule. And the reason why this is of another dimension altogether is we normally say that our protection against autocracy is election. But if autocrats are stealing elections, then you can't check the autocracy by using elections. You have to use something else, which is the rule of law. And I think what Ray's book suggests in this chapter is the need for stronger rules, the need for stronger guardians, and the need for stronger enforcers. And what I think he appropriately does is, with regard to the rules, he says, look, we've moved beyond the Watergate rules, and maybe even the Watergate reforms that have driven legal education for the last 50 years, because now it's not just that lawyers are making false claims or filing arguments that have no legal basis. They are showing a fundamental disrespect for the rule of law in order to subvert democracy. And one of the people who's doing this is the former U.S. attorney for the Southern District of New York, the former mayor of the city of New York, the person who people look to for stability after 9/11. And then people who were the assistant attorney general for the environmental division, the former Supreme Court clerk, John Eastman, and that they do a series of barefaced lies in the face of rules that are supposed to prevent them from making such false claims. On who the guardians were, and I think that government lawyers gave a lot of ground to Trump, but they did draw a line, and it was pretty late on January 6th, where they said, if you're going to adopt what Ray calls the proof of concept scheme, where you're going to dismiss the acting attorney general, Jeffrey Rosen, and replace him with Jeffrey Clark, we resign. And these were staunch Republicans. But I think that what they were signaling was, we have our limit, and we're going to tell you that our devotion to the rule of law is greater than to your rule. And it was significant that in the DC bar ethics hearing that Jeffrey Clark was just recommended for discipline, he said, my client was Donald Trump. And my colleague here at Yale Law School, Don Elliott, another Republican lawyer, environmental lawyer, said, no, he's not. Your client was the American people in the Department of Justice, and you did not live up to your obligation to them. And then finally, I think the role of the courts, but also the engaged public. There's a tendency, I think, to be quite passive in the face of this history of abuse about what's coming up next. We have an extraordinary situation now. We normally think about the president as protecting us from national security threats, but we have someone running for president who is a national security threat. And, the New Yorker reported that General Milley of the Joint Chiefs of Staff in the waning days thought that Trump would divert attention by drawing troops into the streets, or that he would bomb Iran. He's made absolutely no bones about what he plans to do. When asked by George Stephanopoulos, would you look at opposition research from Russia or China? He said, yeah, I would. So we are really facing a new crisis, and into this crisis comes Ray's book, which I think reminds us of the fact that the lawyers are the problem, but the lawyers can also, lawyers like those on this call, be the solution. Sorry to go on so long.
Terrific.
I'm gonna take a quick pause, Bruce, because I have to do that CLE thing. So I'm gonna put it for those taking CLE. I'm gonna share my screen. So you can see the code. This first code is DEM, DEM 10. DEM 10.
The second will be Republican.
You'll see. You have to stay tuned to find out.
Oh, I thought it was Dems and Does, but
And D's.
so let me ask you, Rebecca. There was a lot there to respond to. I don't think I need to ask another question.
No, you don't, but thank you for starting off the conversation. And I just want to start out by saying I am also on Team Rule of Law and Democracy, and also on Team Ray, whose book is extremely interesting, incredibly well written. Hard to imagine that this topic would be such a page turner, but it really is. So, so congratulations on that. After having said that, I'm going to disagree, I think, with a couple of his points in response to your prompt, Bruce, because I actually don't think that we're at an inflection point for the legal profession. I would agree with Harold that this is a more significant threat to democracy and rule of law at this moment, to have a president like Donald Trump, who perhaps is going to have a second term emboldened the way he has been. So I would agree with that. But in terms of the legal profession, I don't think it is significantly different and worse than it was before and has always been. I think there are always bad lawyers, unfortunately, and always good heroic lawyers. And I don't think the profession has behaved particularly differently in this moment. And I want to say that I think that the lawyer's obligation is not to the rule of law writ large. I think if you read the preamble, it never says that. It says that the lawyer's obligation is to the administration of justice, to the courts. And so the lawyer's role is indirectly to the rule of law, and their role is in representing their clients within the bounds of the law. And I think it's hard to distinguish a lot of the conduct of these lawyers from the conduct of most lawyers. And actually, Ray, to his credit, acknowledges this in the chapter. I think that especially given the fact that these memos, I'll talk about John Eastman, and I should say that I was briefly an expert witness in his disbarment proceedings. My testimony ended up being precluded. I don't think that makes me biased in any way, but I just, as an ethics person, I think I should reveal it. In any case, I'm opposed to treating this problem with lawyer discipline. I do think it's a problem, and I think it's a problem. The moral issue that Ray raises, I'm completely on board with. I think we need more lawyers who treat law as something with real meaning, real boundaries, that has real teeth, such that when you say you're representing a client within the bounds of the law, that means something. And I really think we need more lawyers who treat the law that way. And I hope in my classes, and I'm sure my colleagues in their classes, try to inspire their students to be that kind of lawyer. But that said, I think discipline is really the wrong way to go. And I'm just going to take a minute to explain why. First of all, I think there's no neutral principle that one can use to distinguish between what the lawyers in these cases did for the most part and what lawyers do on behalf of their clients. So Eastman was floating, right? Those were internal memos, floating aggressive legal theories with and kind of parroting back allegations made by the client himself. What lawyer doesn't? I mean, some, but there's certainly regular lawyers who do that. I think it's extremely hard to come up with a rule that distinguishes that. And that's why when you look at the opinion in California, it uses terms like he acted negligently toward the law. His view of the law was not as robust as what it should be. And the rules are so vague in California that he can be disbarred for something like that, I guess. But that seems problematic to me. And it seems problematic to me because without a neutral principle, the regulatory system has really opened itself up to allegations that it's been weaponized. And when I said that Ray acknowledged that, he sort of tried to distinguish when it would be appropriate to discipline people and said, we don't want to discipline cause lawyers. Okay. And then he says, well, maybe it's if you're acting on behalf of a marginalized group, well, then you can have these aggressive theories of law. And, I find that really troubling and problematic. And I especially think we're living through a moment when who gets determined to be marginalized and who not is considerably a subjective category. And I don't trust anybody to say these are the lawyers on behalf of marginalized people who get to make these aggressive claims when these lawyers don't. I think this has echoes of really troubling times in the past when lawyers have been disciplined for representing very unpopular clients and taking very unpopular positions that were supposedly against the rule of law, like, for instance, during the McCarthy era. I think it sets a very bad precedent for the future in which you might want lawyers to be able to challenge the government in this way. And I think that the ways in which that Ray has suggested, while I'm very sympathetic with them, I think we have to think of more creative ways to inspire lawyers to be like Jeffrey Rosen, the lawyers who stood up to Donald Trump, rather than punish these lawyers who I don't think, I'm sorry to say, are going to be deterred by the fear of discipline. I think they're going to do whatever they're going to do for power's sake, and they're always going to be there. Lawyers are no different than the rest of the population. So there are really, really awful people, and there are really, really awful lawyers. And I just don't think that's surprising. And I think we should focus on our efforts on how do we create a culture within our profession that inspires more people to stand up for what is right at these critical moments than using discipline, which is going to be dangerous and set dangerous precedents and, cause problems for the profession that are more significant in the future.
Thanks.
If I could just jump in for a second, Bruce, forgive me if in the book it's not clear. I certainly do not suggest that there should be different rules for people who are supporting, majority rule versus those who may be cause lawyers for the marginalized. I say that we have to be careful that any kind of rule is not wielded against lawyers serving marginalized communities as 1983, when the amendments, the 1983 amendments to Rule 11 were used and were brandished against civil rights lawyers. And that I say that we have to be careful not to do that. But I do not say that there are different, I don't think I say, and I certainly don't support there being different standards for lawyers engaged in different, on behalf of different communities. I just say we have to be careful that we don't substitute, sort of conventional wisdom and, someone who might be representing an individual in a death penalty case in a community where, based on their, ethnicity or their race, they might face discrimination. I do not suggest that lawyer should have a free rein to engage in frivolous conduct. So that just to be clear, and if anything I have written might suggest that is not my intent.
So we can come back to some of this, including Rule 11, but I wanted to give Steve Younger a chance to weigh in.
I was hoping I get some equal time here, Bruce. No, this has been a fabulous discussion. First, hats off to Ray Brescia. One of the things I love about him is that he is the Harold R. Tyler Chair at Albany Law School. Judge Tyler is one of my mentors and heroes. He did have one black mark in that a fellow mentee was Rudy Giuliani. And so I never filed a bar complaint against Mayor Giuliani, but not just for that reason, but for other reasons. But I think the reason it's important to remember Judge Tyler, and you talked about it at the beginning, Bruce, is he was Deputy Attorney General of the United States in the wake of Watergate. And I think that frames how I view the world of ethics. But first, let me just respond just 1 minute to Professor Royfi. I think lawyers are different. We have to abide by a higher standard. We owe duties, and a lot of people don't understand this. I know you do. We owe duties to things beyond just our clients. The ultimate fear of every lawyer is they could get disbarred or at least written up, or they could be accused of malpractice. And I think that shapes at least some of the thinking of lawyers, but hopefully lawyers think more aspirationally and don't sit around worrying about what could go wrong, but instead aspire to what they can do right. I want to talk a minute about Watergate because, as I'm sure Bruce can commiserate, it led to a lot of the ethics rules that we have today, but also led to a lot of changes in government. And I remember quite vividly Archibald Cox, who disobeyed an order of the president and was fired as special prosecutor. Distinguished him from John Mitchell, the Attorney General of the United States, who was convicted of conspiracy and obstruction of justice. Those were very unsettling times for anybody who either was a lawyer or was about to be a lawyer. I think it was an inflection point. But here's the difference from today. We had a bipartisan sense of government. We made so many reforms. I'm not sure, you could fill all the reforms on Professor Green's bookshelf because there was so much that was done about it. In my mind, what happened on January 6th was a ton worse. Yeah, you had somebody who was in the White House who broke the law, but he left the White House voluntarily, and observed the notion that we have a country that had a successor that was going to take over for him. Donald Trump did not want to leave the White House voluntarily. Donald Trump incited an insurrection, and guess what? Nothing really was done about it. Yeah, we had investigations, we had hearings. Did we pass any laws? No. Did we pass any regulations? No. We had a lot of people who were really worried about it. And that's my bigger concern. If you think about the Trump approach to law, it's calling decisions phony decisions. It's calling judges so-called judges. It's calling judges political judges. And I can tell you, I did a panel at the ABA with a bunch of those judges. They all feel like they're viewed as politicians, not people who hand down the rule of law. And that's my biggest concern about where we are in America, is we have people who don't actually believe there is a rule of law. It's a rule of politicians. And I think that we are at an inflection point, and I think how we come out of this is going to depend on a couple things. One, the outcome of an election we have in November, but I think also the outcome of these trials. Personally, I wish the January 6th trial was going first, because I think that would, allow America to get closure on these issues. But we are such a divided country, and if our country says, yes, a jury spoke and comes behind the result, I'll feel a whole lot better. But I think ultimately what we as lawyers can do is to educate the public. I think there's a huge crisis in civics. The average person thinks that the three branches of government are Democrat, Republican, and conservative. Maybe conservative is going to be your last code, Teo. But I think that ultimately we have to educate the public to understand what happened that was wrong, but more importantly, what we aspire to in terms of the rule of law and in terms of democracy in our country.
I see Harold has his hand up, or virtual hand up.
I disagree with Rebecca that this is just what other lawyers do. On the one hand, what Jeffrey Clark did was he alleged irregularities in the election that did not exist and that he knew did not exist. That's false. He asserted a false statement as true. Now, you know, Ronna McDonald did the same thing as chairman of the RNC, in which he goes on to become a paid commentator for NBC. They withdraw that because basically, how can you trust somebody who's going to assert that there are irregularities when these irregularities did not occur? And secondly, I think what Ray was saying is that Rule 11 says you should not make frivolous allegations of law, but he's saying that these are allegations that go beyond frivolous. They go on to affirmative attacks on the structure of the rule of law itself, that they are completely made up legal theories that have no basis, and including relying on non-existent facts, and that is something of a different character than just pushing the facts and the law in your direction in an effort to act zealously for your client. And then finally, I think that there's a tendency that a lot of people have to say, throw the rascals out. And once they're out, you know, we'll learn the lessons, etc. It turns out that that tends to actually allow them to, you know, rehabilitate themselves. Discipline sends a mark that these people can't practice law anymore, and that you shouldn't believe what they say as a matter of fact or as a matter of law. I was just down at the New Orleans Book Festival, and a reporter named Jonathan Martin described that he was coming down the elevator at 2 o'clock in the morning on January 6th, and who was on the elevator but Mitch McConnell. And Mitch McConnell said, "I am so happy he's done," meaning that Trump is done. And he'll never come back from this. So, and then, as you know, the next day, McConnell got up on the floor of the Senate and said that Trump bore moral and political responsibility for January 6th. Well, then what happened? They impeached him. It goes to the Senate. 10 Republicans join. I'm sorry, 7 Republicans join 50 Democrats, so you have 57 votes to impeach. And McConnell votes against it, saying, well, he's leaving office anyway. So he's throw the rascals out. Why do we need to do anything more than that? If he had just gone the other way, you would have 10 more votes. He would have been impeached, and he could not stand for election again. But now, in fact, we're looking at him again, and he has a lot of lawyers who are defending his conduct and their own conduct and the conduct of his lawyers as within the realm of the acceptable. And I think Ray is perfectly correct to suggest that certain kinds of behavior by lawyers is out of bounds. And if they lie about the facts or manufacture legal theories to undermine the democratic basis of our government, those are abuses of power and shouldn't just be ignored. They should be sanctioned.
Can I just clarify that, so first of all, there is no rule against making frivolous arguments in public. The Rule 3.1 is specifically designed to address arguments that are made that don't have a basis in law, in fact, in a courtroom. And that is precisely because lawyers' obligation, if you look in the preamble, is not generally to the rule of law, it's to the administration of justice. And lawyers all the time do, in fact, make frivolous arguments to their own clients, as Eastman did in these 2 memos, to float them out to third parties before they actually have researched the law or the facts, parrot crazy claims that their clients are making on behalf of, and before they go and look into them and before they file a complaint. And I don't think any lawyer, and I would defer to others, but I don't think any lawyer would ever be disciplined for that general conduct. Now, Jeffrey Clark, as you're right, that he, unlike Eastman, actually seemed to be trying to make this in a statement to a third party that might implicate some administration of justice, but it would be an attempt because the letter never left the White House. So we would be disciplining him for attempting to lie on behalf of a client to a third party who's not a part of a, where there's no effect, I would think, on the administration of justice. I think that's problematic from a First Amendment perspective, but at least that one's closer. But I do think it's important that I guess I share your upset and I share your anger and I share your concern about all of these issues. I just think we need to be careful about what ammunition we use to address those, because sometimes the medicine is worse than the illness. And for me, the implication that this has for the legal profession's regulatory process going forward are more serious than the problems that it would ultimately solve, which I think are very small. I think the real solution comes from creating more Jeffrey Rosens in this world. So I don't think it's a way to distinguish these lawyers' conduct by saying they were making frivolous arguments, because I think lawyers do that all the time. If they file those arguments in court, by all means, they can be disciplined by that court. But that's different from what happened here. These were the 3-page memo and the 6-page memo written by John Eastman were being sent to his own client and then potentially to Pence, who might have been his client, but might not have been. And he was parroting back allegations.
Can I just ask a question?
Can I just,
if I make an intentionally bogus argument to my client, that's not disciplinable?
But it's not, sorry. I mean, I don't want to.
No, I just want to make sure.
I mean, and I defer to your greater knowledge on this, but I mean, I think the thing is, if your client says to you, hey, let's brainstorm some ways in which we can think of a really aggressive way to fight X company on this issue. And they say to you, and here are the facts. And you're like, okay, that's the facts. Well, here's my aggressive theory, which is, if you look at those memos that Jeffrey Eastman wrote, they were they were precisely that. They were like, here's one way, here's another way. This one's super bold. Like, essentially brainstorming with your client about crazy ideas. If you think this was actually a lie to Trump, I guess, but I don't think it makes any sense to view it that way when he was the one who was saying, I want to get to point Z. How do you help me get there? And he says, well, here are the ways that we would do it. In a session, in a closed, while you're talking to your client, that's discipline. Like a normal lawyer would get disciplined for that. I just don't think so. And my guess is that
I think you're missing the point. I've represented the President of the United States. I've represented secretaries of state. I represent Attorney General. They say, what's the most aggressive argument you can make for this? You say, you could argue this, you could argue this. This is within the realm of law, and I will represent you zealously. But if they say, will you argue this? You say, no. Why? Because there's no basis in fact to make that argument, and there's no basis in law to make that argument. And you could say, and by the way, if I made that argument, I would be disbarred, and I should be, because after all, my client is not you personally, Barack Obama or Donald Trump. It is the Constitution of the United States of America, which I took an oath to obey. So I would not throw out these theories. I would, and I think, knowing that people will be disbarred for putting forward certain kinds of theories or putting them into legal filings, etc., is entirely appropriate under these circumstances. Mark Milley, the Joint Chiefs of Staff General, was asked by Trump, why don't you launch, according to the New Yorker magazine, Peter Baker and Susan Glasser, why don't you launch an attack on ballistic missiles inside of Iran after January 6th as a way of distracting attention from January 6th. And he said, if I did that, we would be tried as war criminals in The Hague. So he said no. So sometimes when you're being given an unreasonable request by an unreasonable client who has no fidelity to the rule of law whatsoever, it's very important that you be able to say no, because that's not within my legal role.
Yeah, and I entirely agree with you. I just, except for one thing you said, which is that you should be disbarred if you do something else. I absolutely agree that that is the best way to be a lawyer, to approach the law, to treat a client, to act in these circumstances. I wish we had more lawyers who are like you, but I think disbarring people for acting differently it creates a very hard line
Why
drawing
should they practice
situation.
law again? You know,
And
why should they practice law again?
historically, there were lawyers who represented communist clients who were, disbarred for similar sorts of vague rules with the same idea that what they were doing was undermining the rule of law. And I think we can look back at that as a dark piece of history of the bar, and I don't think we want to repeat it. And I don't think there's a way of distinguishing other than, I know better, which is not a principle. It's a, if I could anoint you not just as dean of Yale Law School, but as the person who gets to decide which are worthy and which aren't, I'd be fine with that. But lawyer regulatory agencies in all of these different states making that call, that seems very, very dangerous to me.
So go ahead.
Well, I was going to say, I mean, you say that lawyers make frivolous arguments all the time, Rebecca, and state bar, state, disciplinary committees check those actions every day.
Outside of court?
Oh, well, I think that January 6th is worse than not, filing in court, because the mob was motivated by the legal guidance that Eastman gave to Trump, that it was, here's the match, there's the fuse. And and Eastman even says, if we bring these claims to court, maybe we'll get one justice on the Supreme Court. Maybe, right? So he knows the cases won't win. Now, I'm not saying that you have to win a case for it not to be frivolous, but he made a calculated decision that this is not a claim that's going to survive in court, and urged, just as the president said, come out on January 6th, will be wild. The reason that they were focused on January 6th was because of the legal guidance, you say floating aggressive legal theories, right? It was more than just floating aggressive legal theories. It was harnessing the mob and taking actions like creating false slates of electors. So if it was,
not to mention, potentially hanging the vice president,
and I wouldn't, maybe, Eastman, we can't pin that on him. No,
but the role of the vice president, you can.
That he said that the vice president could do this, but it was more than just, an academic exercise, sitting in the back of his, his office on speakerphone saying, well, if there were alternative slates of electors that were certified under the ECA, maybe you could see a path through. No, this was manufactured. He knew that there were no legitimate alternate slate of electors. He encouraged people to gather those alternate slates that were utterly illegitimate. So it's more than just floating legal theories. He encouraged action to be taken, not even if there was no mob, right? He encouraged the manufacturing of alternative slates of electors, and set forth a strategy that wasn't just floating, hypotheticals. It was designed to do something very clear, and that action he knew could not prevail in court.
So that's not what's charged in the disciplinary complaints against these lawyers. If that's what's charged in the criminal cases against the lawyers, and I think if that can be proved, that they actually took actions that were illegal, then their conduct is not within the bounds of the law, and that is fine. But I don't think that's what was alleged, and I don't think that was proved in any single one of those disciplinary complaints or the opinions. And I think that's on purpose, because those are very hard things to prove. And I also think, again, like I'm on everybody's side here, but I think that like level of upset and which I share, by the way, it leads people to blur things. And again, just being careful here. John Eastman's theories were not, he didn't have to do with a fake set of electors. And also, as his defense in that case, and I think it was pretty convincing, although what I testified has nothing to do with, but was that he presented all three of these options. The one that he went with was the one of delay. Let's delay things and hand things back to the states to see if they can reinvestigate. So I think we should be careful, just because there is this tendency, because everybody is so upset that nothing has been done about this situation, which I am too. Why haven't laws changed? Why haven't people been punished? Why is somebody running for president who's responsible for this? That we just end up using all of that upset toward each problem. And to me, it's important to keep them separate, in part because I do think we really have to be careful about the problem of what would happen if there were a different set of people with different ideas about what is undermining of the rule of law, pursuing the lawyers who were trying to challenge the government in this particular way. And we have to come up with neutral things. And the idea that floating frivolous arguments is going to be our neutral thing seems extremely hard to me to say, because I do really think that lawyers do that quite a lot. And I think, again, I'm with Harold that I prefer lawyers to have a very different attitude, and I would never hire anybody who wouldn't stand back and tell me if I was trying to do some crazy thing that was illegal. But not all lawyers and clients are that way. And so,
I know.
But as someone who practices law every day, I think we spitball and say, well, what about this? What about that? But I can't ever remember putting an argument in a legal memo to a client that, was something I didn't believe in.
I think Eastman believed it. Believed it was, as Rebecca said, I do think that it was designed towards delay. I know Teo probably needs to get a code out, but two, very important points. Eastman spoke on the ellipse. He spoke before the crowd on the ellipse. The same podium that Giuliani said we should have trial by combat in front of the fulminating crowd. I think that crosses a line. Certainly Giuliani crosses a line. I haven't looked at what Eastman said specifically on the ellipse, but it changes the action, right? When you're engaged in the insurrection. I think it's very different from just floating aggressive legal theories. Teo, to you, I think.
Yes, I am not doing the code yet. Although Stephen, I loved your suggestions. As the host, I'm going to take the prerogative just to say a quick word or two. I feel like we're talking about three pathways here. One is that the ethics rules and the discipline they allow us to impose on lawyers are too far and too vague already. One is that we need to strengthen them, which I think, Ray, is what you're saying, and others are saying we need to strengthen them in some way. But we, of course, do discipline advice under the rules, or we're allowed to all the time. We're allowed to. John Yoo in the torture memo case was disciplined because he wrote a memo that said torture is permitted, or not torture is permitted. He said these acts are permitted because they don't constitute torture, even though the law said the exact opposite of that. And he was disciplined. That was a memo, an internal memo that he wrote. And we discipline any kind of advice that is encouraging or assisting a client in crime or fraud. So advice does get disciplined. And I think the question in the Eastman case, and it sounds like there's disagreement. I know a lot of people who disagree on whether or not Eastman was doing that. Was he advising a crime or a fraud, or was he not? But that is that's the crux. We do discipline that kind of stuff all the time. I share with Rebecca, I'm not convinced that we need to make our ethics rules do more than they already do. But part of the reason is I think they addressed this situation. I think that what Rebecca is talking about in terms of we need to improve the culture we have among lawyers to create respect for law is, of course, what that means is really challenging, right? And that could be a whole separate panel on how do we create that, and how do we create consequences, because I think to create that culture, there have to be consequences, and are the rules we have sufficient? But I do think right now, if you look at the rules, they're being used, and maybe I'm the middle ground here, and then I think they're being used appropriately. I don't think we need more, but I certainly wouldn't pull back on what, maybe you can disagree with the Eastman decision, but I wouldn't pull back on what we have available. No code just yet. That's still coming up later.
Am I
Bruce,
wrong that John, you
Bruce, if I
wasn't,
could
that
get,
John, you wasn't disciplined? I just want to get that. Was
Right.
John, you disciplined? I thought he,
No,
the report was
Peter
overturned.
Margulies just made a point in the chat. So the Office of Legal Counsel, Office of Professional Responsibility, excuse me, initially recommended that he be disciplined, but their recommendation was rejected by a high-ranking Justice Department lawyer. But in any event, to get a little bit away from the specifics here, I do want to throw up
before we do, Bruce, can I just,
Yeah.
this is one of the values of Ray's book. You know, even if you watched a lot of television coverage, this chapter of the book, chapter 7, very crisply states the theories that were being put forward and clarifies that, you know, Eastman is basically arguing that the Vice President Pence had the legal authority to disregard the votes of 7 different states on January 6th. And he pushes that theory to the Vice President's own lawyer, Gregory Jacob, who's in the government. And then Jacob says, quote, "It was gravely, gravely irresponsible for you, Eastman, to entice the president with an academic theory that had no legal viability and that you well know we would lose before any judge who heard and decided the case. And if the courts declined to hear it, it would only be decided in the streets. So that the knowing amplification of that theory through surrogates whipping large number of people into a frenzy over something with no chance of ever attaining legal force through the actual process of law has led us to where we are," which Ray calls legal theories in service of mob rule. And I think that that is something that is really of a different magnitude from what we've discussed. And, you know, Rebecca, you know, on the one hand says there's a great chance of this all being abused and people being unnecessarily disciplined, but then she turns around and says these things are very hard to prove. So my view is, well, you know, if people are falsely charged, they can defend themselves and end up saying, look, I'm not John Eastman, I'm not Jeffrey Clark.
So can we talk a little bit about what the implications are for the profession? I mean, eventually the California court is going to decide Eastman's case. The DC Circuit is going to decide Jeffrey Clark's case. The New York court is going to decide Rudy Giuliani's case. These are the 3 cases that Ray raises. But for the moment, you know, Ray says the rules ought to be strengthened. I think Teo says no. There's some suggestion about culture. I will say, after Watergate, the thing that the bar seemed to agree on was that legal ethics professors weren't doing a very good job and we needed to do more. Thankfully, that was not a chapter in Ray's book. But I guess I would ask, so what are we supposed to do about all this? Was this just a few aberrational lawyers caught up in you know, whatever they were caught up in January 2021? Or does this have implications for us, our rules, our disciplinary process, our culture, our bar leadership? You know, what are we supposed to take away from this other than it's a great read?
Yeah, I think we were caught up in a politics of personality. And I think that's why these people did as much as they did. And unfortunately, we have such division that probably about a third of the country still thinks the president did nothing wrong. And so that makes it quite difficult. I'm not for wholesale changes to our disciplinary process. Our disciplinary process works, and we have to see how it plays out in these cases. I think the bigger thing is education. I think, programs like this where people learn the lessons of these kind of cases. Judge Tyler did an article shortly after he left the Justice Department on the Attorney General counsel to the president or counsel to the country. We need more ethics lessons to our government lawyers about who their client really is, so that they don't get caught up in these kinds of politics of personality. And to me, that's the ultimate answer. And unfortunately, I think we need a lot more education in our grade schools about what our government involves to begin with, so that when people actually go in and become voters, that they would know what they're voting for.
Okay. Harold?
Yeah, I think I stressed before, not just stronger rules, but stronger guardians and stronger enforcers. The guardians in the Justice Department were career lawyers largely, or political lawyers for whom this became too much. But what's interesting is how many times they bent up until, January 6th, which was only 14 days before the end of the administration. And what Trump has made clear is if he's elected again, they're only going to put in pure loyalists. So those guardians are going to be much weakened, and he's going to try to purge the civil service of people who might resist him. So that's a source of concern. Second, what about enforcers, the courts? I don't think any of us fully appreciated that the courts can be largely taken out of the picture by endless motions for delay, even on totally frivolous theories. And, the number of motions for delay got Trump through his entire administration, and is essentially preventing or threatens to prevent this issue from being tried before a court before he might be accountable again at the polls. So I think that we have to think a little bit about whether the judges are doing enough. I'm not sure, for example, why the Supreme Court didn't just deny cert on his request for absolute immunity, which strikes me as essentially frivolous. A great thing yesterday was that 19 former military leaders and four-star generals filed a motion saying to recognize his immunity puts soldiers in an untenable position because they'll be asked to execute unconstitutional orders, and then if they do it, the president will claim immunity for it, and this puts them in a tension between their own oath of service and their duty to obey their commander-in-chief, or the person they perceive to be their commander-in-chief. So the real question we should be asking is, how did it get this far?
So go ahead, Becky.
Oh, okay. Well, I was just going to say, as I realize that I'm in the minority in suggesting that I don't think the disciplinary agencies are the way to go in terms of shaping and reshaping the profession, or trying to encourage lawyers to be the kind of government lawyers that Harold Koh was, that Jeffrey Rosen was, that some of the people that we saw do the right thing were. But I do think that the way to do that is to focus on the institutions in which lawyers practice. And I really do think this is extremely important, and maybe we can all agree about this, which is that the lawyers, the problem is when lawyers mistake their ideological goals or their partisan desires for what the law will always be or dictate. That's kind of a Donald Trump playbook thing, which is when the law comes out my way, the law is legitimate. When the law comes out against me, the law is illegitimate. And I think there's a little bit of a risk that there are certain lawyers who are starting to view the law that way, and not to view the law the way that I was taught to view it, which was kind of classical, but they argue this side, they argue that side. The practicing law and studying law next to people with whom we disagree is how that culture is created. And I think, you know, we can disagree up to a certain point and we can fight with each other. And then there's something where it's like, oh, no, you've gone too far. That's not a legitimate argument anymore. And that is part of being in a community that values certain things that are beyond politics. And so I really do feel like the way to strengthen the profession is to strengthen our law schools, our law firms, our legal practice, and to make them truly places where we focus on professional values, not on ideological or social justice objectives. And that is, to me, again, the way that we encourage and inspire lawyers to do the right things. I think everybody, even people who think discipline is appropriate, will agree that discipline alone is not enough, that we need to do something else. And to me, that's the way to go, because the lawyers, even like take Bill Barr, like he'd been fighting forever. And then he was just like, I've had it. And that's because even he was like, at a certain point, I don't view the law as infinitely malleable. And it comes from having been brought up in certain institutions, I think, that value certain ways of reading the law and ways of interpreting the law, and excludes certain other forms of reasoning about the law and as illegitimate. And that comes from working with people who don't agree with you about outcomes.
Yeah, and I agree with that, but unfortunately, I think it begins before law school. On many campuses, I understand, and I teach too, that there is no diversity of thought. And there are people who feel like unless they have a particular strain of thought, they're not really welcome to speak up in class. But I think the bigger problem is that our young folks are taught that, you know, everybody's right. And, you know, if I ever tell you you're wrong, you're going to feel awful, you know, which is why, you know, everybody in a sports event gets a certification of participation as opposed to an MVP. And so we don't really teach people how to deal with adversity. We don't teach people how to deal with difficult thoughts and difficult conversations. And I, have a dear friend who's chairman of a political party, which is not mine. And we talk once a week, and we talk about all kinds of things. And we know what we can agree on and what we can't agree on. But I think many people, if you're on one side of the aisle and I'm on the other, geez, we don't even talk. I mean, a number of people I know who stopped having dinner with people following the Trump election. You know, why is it that you can't have dinner with someone because of who they voted for? This is how divided we are in America.
So I feel like maybe this topic lends itself to a fair amount of negativity about the planet, the country, the state of our politics, and even the legal profession. But, you know, Harold was talking about judges. It strikes me that if the story had ended on January 5th, we would, at least as far as judges are concerned, have a pretty positive story to tell.
Oh, yeah. There were lots of what we call Trump judges who ruled against Trump on the election cases. I mean, that's why, you know, his storyline about political judges just really troubles me. You know, there are some judges who are, you know, far left or far right, but the average judge I know, when they take the bench, they're not thinking about politics. They're thinking about the rule of law.
And we could also talk a little about, I think, Harold raised issues about government lawyers. If you look at the Jeffrey Clark story, I think that's a positive, not him, but otherwise, it's a kind of a positive story about government lawyers, because the other Justice Department lawyers pretty much shut him down when he wanted to, support the false narrative that there was massive illegalities in the voting. Can't we take away? Is there any way in which we could take away? Say this was a great thing for the legal profession, aside from a few bad apples, and then we could debate the extent of their badness.
I don't think it was a great thing, but I think it's a
Yeah.
good object lesson. I think two things. One, when you go into the government, when I was the head of an office of 250 lawyers, I said, look, when you're representing your client, you have a duty of zealous representation, which means if there's a plausible theory under which you could say yes, you have a duty of fearless advocacy. But if what you're being asked to do is beyond the pale, you have to say no. And so practice saying no. And you, so don't say no when you should say yes, but absolutely don't say yes when you're obliged by the law to say no, because your duty is to uphold the Constitution and laws of the United States of America. It turns out in government, if you say no, you're usually more respected than people who just say yes all the time because they want to get somewhere or be attorney general or something like that. The second thing I think we shouldn't overlook in government, Bruce, is the role of whistleblowers. John Dean was a whistleblower in Watergate. Eugene Vindman, who is a Ukrainian-American Republican official in the National Security Council, overheard Trump's conversation with Zelensky and couldn't believe his ears. And so he reported it. And then it turned out a whistleblowing mechanism had been created. And so the CIA general counsel then reported it back. And through the channels, it ended up becoming information that people had to act upon. So it turned out that setting up that whistleblowing mechanism turned out to be a critical way whereby someone who had observed what they thought was a violation of the law could report it. And in government, therefore, creating these kinds of formal protected dissent channels is even more important.
So one question I guess I want to raise, which you kind of suggested a little bit, is the idea of the government lawyer either contested or under stress? Because Becky said that even Bill Barr had his limits, but before he had his limits, according to Jeffrey, who is the U.S. attorney in the Southern District? There's somebody Jeffries here, but
Berman.
Berman. According to Berman, Barr was kind of doing the president's bidding in trying to shut down a case against the Turkish National Bank, because at that moment, at least, Trump viewed Turkey as a friend of his. And other career prosecutors quit when they thought that Bill Barr was interfering. And I think the post-Watergate Justice Department reforms were directed toward depoliticizing the Justice Department, but there is a theory, and Bill Barr espoused it, about the unitary executive. All power comes from the president, including prosecutorial power. And if Trump says lock her up, or I'm going to use the prosecutorial powers, he kind of threatens to do, to go after political enemies. There's at least some people, even in academia, who I think might support that theory, at least if there's like probable cause, perhaps. Do we have to worry about what the future role of government lawyers is going to be, that they're not going to be tempering the excesses of the politicians, but that they're going to be feel compelled to carry out the orders of future President Trump's or presidents like him?
Well, I think the beauty is, and Harold probably knows the number, but the vast majority of the lawyers in DOJ are career lawyers. So they don't, their lives don't turn on who's president today or president tomorrow. So I think that's an important thing to bear in mind. But
that's something that a new Trump administration wants to change. I mean, seriously,
Yeah, I know.
I would like to come back, if it's okay, Bruce. I would like to come back to the point about young people, and we're all educators, and even Steve, even you're always educating about the law. And I one point, Rebecca, you've said that the preamble doesn't talk about rule of law. It actually does. A lawyer should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. So we've been talking about young people this and young people that. You know, I think, Steve, you said participation trophies. I don't think the young people were the problem here. I think the problem wasn't participation trophies. I think the problem was that people like John Eastman and Kenneth Chesebro and Rudy Giuliani and Sidney Powell, none of them particularly young, thought that you should win at any cost, which is the opposite of participation trophies. And we can talk about certainly information silos 100%. People are in information silos. I think people don't talk to people who they disagree with. I think that is a really big problem with our culture, that people, don't get their information. There's no shared sense of information. What did Senator Moynihan say? You're entitled to your own opinion, but you're not entitled to your own facts. And I think we're in a world where people think that they're entitled to their own facts. But I'm also inspired every day by my students. I know all of you are inspired by your students every day, because they are entering this world that we have created, right? That our generation has created, and created a system where it seems to be okay to do some of the things that lawyers did, if you can get away with it. And I would like us to say that we shouldn't be able to get away with it. And that's the lesson we have to impart to our students and to the next generation. Yes, we can talk about, participation trophies and information silos, but we have to undermine this sense that you can win at any cost. And if you, it's only crazy if it doesn't work, right? And I don't think we should encourage that kind of behavior.
So I just wanted to clarify that I didn't say that the preamble doesn't mention the rule of law. I know it does. It just doesn't state that lawyers have a specific obligation to the rule of law the way that it does that they have an obligation to the administration of justice, which I think is the indirect way in which the preamble is suggesting that lawyers have a very significant role to play in the rule of law by representing their clients within the bounds of the law. And on your latter point, I think that what we were talking about when we were talking about the information silos was not the question of what to do with the lawyers who behave badly, but rather how to encourage lawyers in the future to behave the way we want them to behave. And we can disagree over whether or not discipline is useful in deterring lawyers from doing the bad thing. To me, it creates more problems than it solves. I understand to all of the other ones of you, it does not, and that's fine. But on a separate point, in terms of encouraging a new set of lawyers who will respect the professional legalistic values that are at the heart of what our profession does, and become the kind of lawyers that Harold was when he worked for the government, is to me extremely important. And I think the information silos work in counter to that, because what it does is it makes you mistake what you think the law should be for what the law is. And I think that is one of the things that went wrong in this situation, was that there were a lot of lawyers who either were lying about it or truly did just think that the law is whatever they want it to be and whatever is consistent with their prior beliefs. And we need to encourage lawyers who can see something even when they want it to be a certain way, or even when their client wants it to be a certain way, and just tell their client it is not that way. In order to do that, they have to have been in classrooms and been working alongside people who have different views in order to figure out where that edge is, because otherwise they are bound to see it as, when the law comes out against what I want the substantive result to be, it is illegitimate, as opposed to, there's a wide range of acceptable, and then there's outside of that acceptable. In order to do that, you just can't educate lawyers and to have them practice the way that they are practicing and being educated now.
So
if I could just say a word about Bill Barr.
Let me just do the second.
Okay, go ahead.
Second one. Sorry, Harold. Here we go. All right. CAP 24, CAP 24 is our second code. You can see it up there on the screen. Okay.
is that for capitalism?
The capital.
Believe it or not, I did not choose these codes,
Okay.
and I honestly don't know. Sorry,
Let's
Harold.
march on the Capitol.
Harold.
I clerked for the same judge that Bill Barr did 2 years after he did. And what I think is interesting is that the Democrats always take the lesson from the Republicans who preceded them and then kind of overdo it. And so Barr, I think, took a lesson from Jeff Sessions, who had consented to the appointment of independent counsel in Mueller. And Trump was so upset by it, he ended up firing him. And then you had Rod Rosenstein. And then when Barr came in with the Mueller report about to issue, Trump made it clear to Barr, as part of being Attorney General, that his job was to protect him. And so we all recall, or maybe it's faded into memory, that during the 24 hours when Barr had the Mueller report and nobody else did, he gave it this very deceptive affirmative spin for Trump that was not vindicated when you actually read it, but by then it was too late. Interestingly, then the response of Merrick Garland is very much to go the other way and to be extremely careful and to appoint independent counsel, to be very deliberate about his prosecutions, and then to appoint independent counsel both for Trump and Jack Smith, and then her for Biden. And, then of course her does something not dissimilar to what Comey did in sort of trashing Biden in the process of, in theory, exonerating him. So, some people like Jack Goldsmith have said, oh, as a result, the independent counsel should be eliminated. I think quite differently. It's just a matter, I've seen a lot of these independent counsels. What matters is, do you appoint people of such stature and seniority that they don't care about how they're perceived, or they're not trying to they don't have an axe to grind. So, Archie Cox didn't have an axe to grind. Lawrence Walsh didn't have an axe to grind. But, Ken Starr did have an axe to grind. Alexia Morrison had an axe to grind. And if somebody Robert Hur certainly has a future that he's thinking about more than he was thinking about just being an independent counsel. And so I think you have to be very careful who you're going to appoint to these positions and give them that kind of independence.
So I will say I worked on the Iran-Contra prosecution with Judge Walsh, and if he was a Republican, he'd been in the Justice Department, he'd been a judge, he'd been a senior partner of a law firm. But I'm pretty sure, that he would have been attacked by whichever side, if it, in 2024, I don't know, he was kind of attacked by the Reagan administration, but that was like nothing compared to what Ken Starr took, or Mueller, or whatever. I think in this generation, there's nobody in the galaxy who could be appointed to that position who, would come out unscathed. That's my own feeling. So getting back to, so first of all, we have 12 minutes. And if anybody who's listening has a question or comment, put it in the chat, and Teo will read it. But on the question of education, I guess I feel slightly defensive, although none of the people who Ray wrote about as, scoundrels were my students. So I take satisfaction in that. But,
Harold, are you going to fess up about John Yoo?
Well, you were a dean, Harold. Do you think we need to do anything different in legal education, that it was the law professors who were responsible for, what these people became? I find it very hard to imagine.
Wait, can I just interrupt for 1 second? Because I never said that law professors were responsible for the people who did bad things. I was just saying they can play a role in encouraging people to do the right thing.
Okay, I didn't mean to imply anything.
I think that many law schools, and including my own, have over time since Watergate treated the ethics requirements as the students increasingly treat as kind of a rote exercise to be done before they take the MPRE. When in fact we all know that if you are practicing law and you have an ethical issue, it is the thing that keeps you up all night. And it's one of the most troubling and disturbing things that can happen to you, to be caught up in a professional ethics issue. So, I don't know if it's a matter of how we teach it, whether we should use more experiential exercises, whether we should have people who have faced huge ethical challenges giving more speeches to our students. But it's not just about taking the MPRE, checking a bunch of boxes and then being done with it. This is actually something that you have to think about and flag and see these ethical problems before they arise and try to head them off. And I think where I fault deans is I don't think we've done enough to say, look, it's 50 years on from Watergate. We need a different kind of curriculum that will grab these students more. And then really feed it to them. So, for example, I teach procedure, and I've determined to make at least a big chunk of the course professional responsibility, because it's something that lends itself to the topic. But it's not something that's part of the required syllabus, but it just seems to make a lot more sense to do it there. So, I spend time on Rule 11 and things like that.
I will just say,
as a student of Harold's, I can tell you that when he was on the business end of a Rule 11 motion, I learned a lot about being a professional lawyer. And Harold was nervous that that his house was on the line when he successfully fended off that Rule 11 motion, I will say. But Harold, that taught all of us who were your students, how serious this could be. And I think having students recognizing that it isn't, do what you can, see what you can get away with, but rather that, there can be serious consequences. And of course, Harold didn't do anything that was frivolous at all, not even close.
So by the way, I hate to raise this, but I have to totally agree with you, Dean Coe. I was scheduling the final exam in my class, and the students said, "Oh, we just have professional responsibility the next day. You don't have to worry about that." And I said, "Yes, you do." But I also had the misfortune of representing somebody earlier this year who was one of the people accused of submitting a brief with ChatGPT cases. I can tell you, he saw a new God. He really looked at his inner soul, but I only wished he'd seen that God when he filed the brief.
So I was just going to say, by the way, just to be clear, that I don't think there's a deficiency in the teaching of legal ethics, Harold. I think it's the con law faculty who are doing it. But there's a comment in the chat, which I'll just read, and any of you want to respond to, from Steve Landsman. The problem appears to me to be that we have not effectively pursued the facts in a timely way. The delay played by defense counsel has undermined the rule of law. Don't we need to insist on a speedy and effective process and condemn those who thwart it?
I assume he's speaking about the various Trump proceedings. That would be my guess.
I would think. There's an area where I'm not sure the judges come out as well as they did in the context of the election challenges. They also were not my students. Any thoughts about that or anything else in our concluding 7 minutes?
I think what Steve is saying is, you know, judges ought to be suspicious when a criminal defendant who's claiming to be innocent is constantly asking for delay. It should be in their interest to want a speedy trial to clear their name. And if they're actually doing everything in the opposite direction, it means they're doing it for tactical advantage.
But I think the problem is the judges know that. But when the case keeps getting taken away from them, there's nothing they can do, and they can't set something down for trial because the case is in a higher court.
Well, I mean, I'm not like the foremost authority in any of this stuff. I thought, but you know, people have said Jack Smith. First of all, it took a long time for Merrick Garland to appoint him, and you know, he took his sweet time before bringing indictments. So I don't know that it's entirely the fault of the judges. In Georgia, you know, there's now an appeal from the judge's decision to not disqualify the elected prosecutor. I don't know whose fault, you know, the delay is there, but I would say, you know,
I predicted early on that the New York County DA's case would be the first one to go to trial. I think I'm right.
Well, we're pretty close. You're pretty close to right. Did you put money on it?
No, I don't usually put money on things like that.
Okay. Anyone have a thought about what's going to happen in that case and how the lawyers will come out? Will it be a good moment for lawyers?
Well, the problem is the main lawyer's already been disbarred.
So not another not a golden moment for the legal profession.
See, my real problem with the case is it's being tried as an election interference case because they basically killed the story so that Trump could survive into the election. The difficulty is America sort of heard that story already, and I would much prefer to see the Jan 6 case go ahead. And the way things are playing out, we'll be lucky if it goes to trial in September.
Bruce, I think the problem with the January 6 case is, you know, they set it for oral argument on the last Thursday of oral argument session. So you'd ordinarily think that they would decide it by June 30th. But partly because it's been pleaded as a case about official acts, where he could have pleaded it based on Trump as a private actor, you know, like Stuart Rhodes calling for incitement and insurrection. There could be a court majority to remand to the DC Circuit to determine whether the acts are official or private, and then that will end up guaranteeing that the January 6th trial won't occur before the election. So, you know, a lot depends on how these justices are thinking about it, which is, you know, the actual substance of the argument is so ridiculous that there was no circuit split on the issue. One of the amusing things is that Trump's lawyers cited Brett Kavanaugh's article when in fact what Kavanaugh's article says is this is why a sitting president is immune, but not one who's not president anymore. And they didn't even
they didn't quote that part. Yeah.
So whether that annoys Kavanaugh enough that it affects his vote, you know, God only knows.
I think that part was written by ChatGPT. So, and any other comments, thoughts, anything? I hesitate to start a whole new line of inquiry.
I think my main thought is going back to what I think is the theme is we need education. I think we need education about civics and what these things all mean. We need education about ethics. And, you know, I've always felt you can't legislate ethics, and we do, we have a code. But it takes somebody who, you know, in the firing line of a president who's saying, yeah, you got to do something to know that their inner soul is telling them, no, I can't do that. And that those are the kind of people that we want to attract into government.
And into the profession.
and the profession, exactly.
I just found in reading Ray's book, as you read each page, you know, you would see examples of lawyers that made you proud to be a lawyer. And then you'd see examples of lawyers who you couldn't believe were lawyers. And it's a constant challenge in reading the book to try to understand where you're going to place yourself. And especially for young students reading the book who may not have as crisp an understanding of some of these episodes as Ray does. It does a great job in presenting both positive and negative role models. And, you know, I've tried to teach some of these cases that's in chapter 7. And, you know, without Ray's book, you know, you have to sign 10 or 15 different opinions or court pleadings. It's very confusing, but Ray's analysis just has a very tight, you know, 10, 15 pages. It can be assigned to any ethics class. And that makes it very useful for, you know, anybody who's interested in the issues.
So that is a great way to end. So I think the takeaway is read Ray's book. And thank you, Ray, for being the occasion for a really interesting conversation. Thank you to the panelists for engaging in that conversation. Thank you to the audience for sticking with us. And is there anything else, Teo, that needs to be done?
No, thanks everyone. This was terrific. What a great panel. And yes, Ray, thanks for that book.
Thank you. Thank you
Give us an
everyone for
excuse to do
the
this.
conversation today. Yes, yes, happy to do so.
Okay. See you all soon, I hope.
Thank you,
Thank you.
everybody.